Good morning, good afternoon, good evening. I want to welcome everyone in the audience as well as a great panel to the session on Arctic shipping of COLP. Just a few words. We have a great panel to discuss Arctic issues today. I'm not going to read introductions because those are available online, and I want to preserve the time for the speakers and for question and answer. For the audience, every speaker has 20 minutes to present. I'm going to hold all our questions until the last speaker has given her remarks. At that point, we'll have questions, and if you have questions, just submit them on the chat, and we will distribute them if you indicate which speaker, I'll try to steer it to that speaker, or if not, I'll open it up to the panel to comment. And with that, I'd like to turn the program over to our first speaker, Professor Aldo Shukop of Dalhousie University, who will give a presentation that I think we'll all find interesting. Aldo, over to you.
Thank you very much, Chair, and thank you very much to the organizers for inviting me to give this presentation. And I must say, I congratulate the organizers for the high level of organization and for being able to convene this meeting despite the postponements, basically, and still enable us to exchange minds online. So my topic essentially comes with a question. It's focusing on Canada and the regulation of Arctic shipping. And essentially, my question here is, now that Canada has implemented the Polar Code, essentially, how might it proceed with regulating proposed low-impact corridors in the Northwest Passage? So in tackling this topic, I will first provide a bit of a backdrop to the question and then speak to the regulatory rationale and say a few words about the application of the Polar Code as generally accepted international rules and standards now applicable to the Arctic, and then introduce the Low Corridor Initiative, followed by a more focused discussion on the regulatory framework before I provide some concluding observations. So by way of backdrop, maritime traffic in Canadian Arctic waters has essentially increased. In fact, one study by Jackie Dawson suggests it has tripled over a 15-year period. However, when you look at the numbers are still fairly low. And indeed, in 2019, there were only 5 cruise ships and 5 cargo vessels that actually transited the full Northwest Passage. Nonetheless, despite the low numbers, we ought to be concerned about the potential for the future, and we are in a position to think preemptively, if you want, or in a precautionary manner. So Canada has embraced the Polar Code through a set of regulations, which I will speak to. So essentially, we no longer have a situation where we have simply unilateral rules under the Arctic Waters Pollution Prevention Act that we had before, in fact, between 1970 and 2017. What we have now applicable is essentially the rules and standards of the Polar Code with relatively few modifications. Now, by way of an Arctic policy position, Canada essentially has identified that safe and environmentally responsible shipping in the Northwest Passage is, of course, a policy and a priority concern. And against that backdrop, Canada has recently been working on this initiative of trying, in a sense, to address the issue of insufficient infrastructure and information that is vital for safe navigation through Canadian Arctic waters. Through this initiative, in essence, try to focus, as it were, its infrastructure building and information generation to those corridors through Canadian Arctic waters that have been in most use. Hence, the initiative for low-impact navigation corridors in terms of focused corridors and receiving support under the country's Oceans Protection Plan. Again, as part of this backdrop, of course, there is the lingering issue concerning the status of these waters. Canada, of course, continues to maintain that it enjoys sovereignty based on historic title, which itself is based on Inuit usage since time immemorial, and has indeed proceeded with delineation of strait baselines in 1985. And at the same time, of course, we know that there have been counterclaims to this claim, and essentially that these waters constitute waters that enjoy international navigation rights, and including essentially claims from the United States, our closest neighbor. And these differences have essentially remained unresolved. So essentially what we have is a situation of agreement to disagree. Now, this may come as a surprise, the last bullet, Indigenous rights issues in Arctic Canada. Usually in the world of the governance of shipping and maritime administration, there is essentially focus on how do we ensure we have safe shipping that essentially produces the least environmental impacts and which is also secure. But in the context of Canadian waters and Canadian Arctic waters in particular, we have to take also into consideration Indigenous rights and interests in those areas which are increasingly being used by ships. So the regulatory rationale. So clearly there is growing interest in the Canadian Arctic, in particular for resource development, but also navigation routes. And we can see in particular, again, among the increased volume of shipping, the growth of cruise ships and venture vessels. These are producing impacts on Indigenous peoples and the environment. Increased ice breaking in some areas have essentially raised issues of safety for Inuit hunters and movement of the mobility, in a sense, of Inuit. And you can see, for instance, that image in Lancaster Sound here. This is depicting Inuit ice routes in one of the main channels of the Northwest Passage. This image was produced by Claudio Aporta, and he has actually also mapped other Inuit ice routes in other parts of the Northwest Passage. So, of course, for the ice routes to function for the Indigenous populations there, you have to have ice. But if you have vessels breaking ice for passage, then we clearly have an issue. Plus, of course, increased vessel traffic is also producing more noise, and noise is having an impact also on the movement of animals. And again, those ice formations that are very important for a variety of animal species in the region. And we're also, of course, concerned about emissions, especially black carbon. And thankfully, there is an initiative now to essentially remove certain fuels from use in the region, because, of course, black carbon itself is a climate forcer. At the same time, the region has hazardous weather frequently. There are serious navigational and other concerns, as well as, of course, ice condition, very variable ice conditions. As I mentioned earlier, the infrastructure is minimal, certainly insufficient even for full search and rescue and pollution response capacity. There's no salvage capacity in the area. Indeed, charts themselves are insufficient, and less than 10% of the Canadian Arctic has been charted, and those charts are not necessarily all up to date. There are issues of survivability too for persons in distress. So there are very real safety and human concerns. And the ability to provide support for shipping in the region is severely constrained, of course, because of the remoteness the great distances. And essentially, we don't really have ports or large ports in the north. They're essentially, whatever there is very small, cannot really provide much by way of a launching pad to provide services. So essentially, to provide assistance in the region, almost everything needs to be brought into the region, whether by ship or by air. And at the same time, though, we're seeing increasing traffic, and of particular concern is small vessel traffic. The fastest growing form of shipping in the region, even within the small numbers of the Northwest Passage, has been recreational vessels, yachts, and so on. And indeed, we had an instance recently of a vessel that did come into Arctic waters, despite essentially being told not to by Nordre. And this vessel turned off its AIS while it was navigating the Northwest Passage. So you can imagine when there is then the need to assist these vessels, the amount of resources that need to be mobilized. And especially if you don't know exactly where these vessels are, the situation could be dire. So let me move now to the Polar Code. And as you know, the Polar Code is now the international standard for navigation in Arctic waters. And it was adopted by the IMO in 2 stages, by the MSC first, then by the MEPC in 2 parts. The first part focusing on maritime safety, the second part on pollution prevention. So Canada started this process of implementing the code fairly quickly, but it took a long time because unlike many other IMO member states, Canada was not starting the implementation process on a blank slate. Rather, it had to take into consideration the existing legislation that went back to the 1970s. So, in essence, the parent act here, the Arctic Waters Pollution Prevention Act, was not amended itself, but the implementation took place through regulations under the Act, as well as under the Canada Shipping Act of 2001. And a new set of regulations were adopted, the Arctic Shipping Safety Pollution Prevention Regulations, in a sense that implement both the safety and the pollution prevention parts. And what is interesting to note is that a large part of the Polar Code was referentially incorporated. So essentially, we'll have a high degree of consistency, therefore, between Canadian regulation and, of course, international regulation, a situation that was not the case before. And as you can see on the slide, in essence, SOLAS itself essentially implemented in this manner, and the MARPOL, a mixture of referential incorporation and other modifications. And I will speak to some of those modifications shortly. What is also interesting to note here is that the vessels owned or operated by a foreign state, whether being used, when they are being used only in government, non-commercial or non-commercial services, are exempted. So this addressed essentially an old issue that we had with the Arctic Waters Pollution Prevention Act that could potentially apply to warships. Now, of course, the fact that there is an exemption has addressed that particular issue. There were a number of consequential amendments to other regulations, and the old regulations for Arctic shipping have been repealed. Now, I mentioned that there have been a few departures, and I'll just mention perhaps some of the key ones here. On the safety side, there's essentially a transitional arrangement because Canada has a system of shipping safety control zones and has a system for risk assessment in navigation called the AIR system. And in essence, these have been kept for existing ships, old ships, and eventually they will be phased out. But of course, at the same time, bringing in Polaris for new ships, and essentially it will be fully phased in a number of years. It's not that there were huge differences between AIRS and Polaris. In fact, Polaris was developed in part influenced by AIRS, but it could produce some slightly different outcomes. Also, other departures concern the ice navigator, which is required if a vessel, especially if vessels are non-SOLAS vessels. So this is particularly important because if there's in the future fishing vessels coming in, and large, perhaps, yachts that could have passengers more than 12 persons, and so on. On the pollution prevention side, the rules have been applied to all ships, so moving away from the tonnage threshold. And there's been retention of an absolute discharge rules to be consistent with the Arctic Waters Pollution Prevention Act, which means that in Canadian Arctic waters, the very minor allowances in clean ballast, for instance, are not even permitted in Canadian Arctic waters. Zero means zero. And same thing with respect to Annex 5 garbage, where some discharges are permitted under the Polar Code. And essentially, Canada has very significantly reduced also what can be discharged in terms of garbage. What has remained unchanged? Well, the definition of Arctic waters, which is inclusive of waters between essentially the meridians on the west and on the east, and boundaries that have been negotiated. And of course, including waters north of 60, which would include internal waters, the territorial sea, exclusive economic zone. And NORDAC, of course, the system of mandatory reporting to enter into Canadian Arctic waters, which is slightly larger than the definition of Canadian Arctic waters, to include the entirety of the Hudson Bay and waters south of 60. Now, the initiative that has been introduced for low impact corridors essentially is aimed to enhance navigation safety in the north, and also to be able to focus services and limited resources in developing these corridors. And the possible services could be many here: maritime traffic services, navigation aids, hydrographic services, weather, ice forecast, ice breaking, search and rescue, pollution response, salvage, places of refuge. And the image that you see here essentially tells you the principal routes which ships have used essentially for shipping, carried out on the basis of a study and pretty much adding up the AIS pings and producing this chart. It may suggest that there's heavy use, but in reality, it's not really heavy use. It's just that it covers a long period of time. So if we look at the corridors, what you will notice here is that on the right-hand side, we have what might be future corridors, the potential for future corridors. And what you have on the left is the 7 different routes that historically have been considered different routes to the Northwest Passage. And if you look carefully at the initially proposed, at least low impact corridors, they do not necessarily fully coincide with all the routes to the Northwest Passage. And that is because, of course, not all the routes in Northwest Passage were actually used because of ice conditions and other hazardous conditions. So what we might see here is perhaps greater focusing of routes. Now we look at the regulatory framework in Canada for shipping, but in particular for Arctic shipping, is actually very, very broad. And of course, there are some jurisdictional issues here that arise within the framework of the Oceans Act, but perhaps even more significantly, some constitutional issues, and the protection in particular of Indigenous rights, which are, of course, constitutionally protected. And because of these impacts and the government's commitments to essentially have partnership in the governance of shipping in the North, in the Canadian Arctic, we will see a greater presence of the interests of Inuit organizations and views in how shipping develops in the North. So as you can see there, this is not to overwhelm you with the amount of legislation. This is what lawyers do, we're always working with the law. But you can see essentially 3 major categories of legislation that would apply here. Of course, those concerning maritime and ports, those concerning the environmental law, especially marine environmental law, and of course, other which concern increasingly Indigenous law, Indigenous rights, and land claims agreements that in some respects also address some aspects of shipping. So those will need to be taken into consideration in developing the corridors, potential impacts, management of traffic, even the role of Inuit organizations in some of the services that might be provided for shipping, including, for instance, potentially being first responders in some search and rescue scenarios. Now, there are a number of issues that arise, of course, from what I've been discussing so far. Canada has not really legislatively defined the Northwest Passage, but it will have to think about how to define low-impact corridors to provide some legal boundaries around the services that are going to be provided, and of course, channel the necessary resources. So essentially, there will need to be regulation, which will be perhaps analogous to the shipping safety control zones. Canada, like the Russian Federation, does not have an administration dedicated to the Northwest Passage as there is for the NSR. So it will need to think in terms of an administrative structure for these corridors. And some ideas have been floated out there. One idea in the literature is, could there be something similar to the St. Lawrence Seaway Commission, for instance? There's more to be discussed on this because, of course, what one has to take into consideration here is the Inuit participation. Will the corridors need an impact assessment? It's a big question. It has not really been raised yet, but we have a new impact assessment legislation here that could potentially be applicable to developments in the north. Then there's the question of routing measures. If essentially we're going to be focusing on corridors, we're going to need routing measures, various kinds of routing measures under SOLAS. And the question here will be, should they be mandatory or recommended? When the corridors were first launched as an idea, the thought was essentially they will be voluntary. So essentially much of the thinking is still that they would be voluntary and even perhaps not necessarily charging fees. But even here, that remains a question. If there are fees for very specific services provided to specific vessels, then presumably those would be commercial services. Will there be a role for the IMO? With Nordirect, essentially the mandatory nature of it, Canada did not request prior IMO endorsement, but simply informed IMO. And of course, we know that there were a number of concerns expressed by other states. Other questions, pilotage could potentially, there might be an argument for mandatory pilotage, but again, we'll have to see how that will be addressed. And issues concerning non-SOLAS vessels and how to ensure compliance of vessels if a vessel decides to switch off their AIS. What do you do? They're up there. I mentioned Indigenous rights and issues, and essentially this map shows a number of shaded areas where it tells you there are land claims agreements, and there will be an interface between these land claims agreements and the corridors. And in particular, ice breaking could be an issue and might have to be regulated in some areas where ice breaking might or might not be permissible, and of course, according to seasonal timing. So recently also Canada launched a new legislative initiative, a bill to implement UNDRIP, and under UNDRIP, of course, Article 26, there's a right of Indigenous peoples to their lands, territories, and resources that has very far-reaching consequences because the territories of Inuit include also ice areas. So there has to be some sort of an understanding of how the governance of shipping will have to accommodate and engage with Indigenous rights. So let me conclude because I'm just about out of time here. So essentially what we see here, Canada has moved from unilateralism to multilateralism in the regulation of shipping. And clearly, low-impact corridors are a common sense approach to managing the safety of shipping. However, the waterway management in the Northwest Passage will be very different from other waterways because we have to take into consideration, as I said, the various factors, especially Indigenous partnership, and whether corridors and the seasons for navigation will be voluntary or mandatory, whether fees will be charged and so on, are still open questions. But of course, it also raises questions for those states that have counterclaimed international navigation rights. Would they consider these initiatives essentially as reasonable in the circumstances, or could these potential restrictions, including restrictions on ice breaking, cause further problems? And of course, an interesting question is regulatory insurance, as I call it. Canada was always concerned in the development of the Polar Code that it might not fully reflect its interests. So therefore, it advocated heavily for saving clauses. One of them was introduced with the new Chapter 14 The other one was already in existence in MARPOL, and in essence that these regulations do not impact law of the sea concerns in Canada's perspective. And one might recall also Canada's declaration on MARPOL that had essentially a similar without prejudice clause. And ultimately, I conclude with the note, what would happen to Article 234 here? At the moment, with the high standards of the Polar Code, perhaps there is less pressing need to use this jurisdiction, but it is possible that standards may need to be scaled up. After all, this is how the regulation of shipping has worked over time. We have increasingly raised standards, and it is possible that there might still be a role for Article 234. And I'll stop there. Thank you very much.
Thank you very much, Professor. Now we're going on to our second speaker, which is Professor Kentaro Wani of Osaka University. Once again, I indicated we'll save questions for the end. So, Professor Wani, please begin your remarks.
Thank you, Professor Barnett. This slide shows the contents of my presentation. Let me make some comments about this. In this presentation, I'm going to examine Russian Arctic shipping legislation in light of relevant provisions of the Law of the Sea Conventions. I divide the provisions of the Law of the Sea Convention into two categories: normal rules and a special rule, normal rules and special rule. Article 234 is a special rule for ice-covered areas. Provisions other than Article 234 are normal rules. Section 2 concerns normal rules, and Section 3 concerns a special rule, Article 234. In this presentation, I'll use these abbreviations. For example, LOSC, a Law of the Sea Convention, refers to the United Nations Convention on the Law of the Sea. I'd like to start with the introduction. There are three main routes for Arctic shipping: the Northwest Passage, the Northern Sea Route, and the Transpolar Route. These routes are shown on the map in the next slide. Given the present ice conditions, the use of polar code is not a realistic option. It is the Northern Sea Route that has attracted much attention in East Asian countries such as Japan, China, and South Korea. There are several advantages of the Northern Sea Route for East Asian countries. First, for example, the distance from the port of Yokohama to the port of Rotterdam is 11,200 nautical miles in case of the Southern Sea Route through the Suez Canal. The distance, the use of the Northern Sea Route reduces the distance by more than 40%. Second, the Northern Sea Route may be used by larger vessels than those admitted for transit through the Suez Canal. Now I'd like to move on to Section 1. In 2013, Russia enacted rules of navigation in the water area of the Northern Sea Route. The water area of the Northern Sea Route is defined by Merchant Shipping Code. The map in the next slide shows it. The sea area is surrounded by red lines. On the map is the water area of the Northern Sea Route, to which the rules of navigation applies. The water area of the Northern Sea Route includes the Russian EEZ, the Russian Territorial Sea, and its internal waters. It does not include high seas. It does not include the high seas beyond the limits of the Russian EEZ. In 1985, Russia drew strait baselines, which enclose several straits in the northern sea route. The validity of these baselines has been the subject of much debate. However, even assuming that the baselines are valid, at the least, the innocent passage regime applies to these straits by virtue of Article 5, Paragraph 2 of the Territorial Sea Convention, or Article 8, Paragraph 2 of the Law of the Sea Convention. According to these provisions, in internal waters newly enclosed by strait baselines, the innocent passage regime applies. There has been much debate as to whether these straits are international straits. I do not discuss this issue in this presentation. The next slide shows the content of the rules of navigation. The purpose of the rules of navigation is to ensure the safety of navigation of ships and to protect pollution from ships. To achieve this purpose, rules of navigation imposes several requirements on ships entering the sea area of the Northern Sea route. These requirements include a prior authorization requirement, a prior notification requirement, and a ship reporting system, and ice pilotage and icebreaker escorting. The core of the rules of navigation is a prior authorization requirement. The entry of a ship to the water area of the Northern Sea route is permitted or prohibited according to criteria such as the ice class of the ship, ice navigation method, water area, and ice conditions. In the next two sections, I'm going to consider whether these requirements are consistent with the relevant provisions of the Law of the Sea Convention. First, I'm going to examine normal rules of the Law of the Sea Convention. This slide shows the basic framework of the Law of the Sea Convention. Navigational rights under the Law of the Sea Convention are largely divided into three categories: the innocent passage regime, the transit passage regime, and freedom of navigation. The innocent passage regime applies to the territorial sea. It also applies to internal waters newly enclosed by strait baselines. The transit passage regime applies to straits used for international navigation. Freedom of navigation applies to the EEZ and the high seas. This slide also summarizes relevant provisions relating to coastal state jurisdiction. Before examining these provisions, I'd like to make some comments on types of standards for the prevention, reduction, and control of pollution from ships. There are three types of standards: discharge standards, construction, design, equipment, and manning CDEM standard, and navigational standards. For example, a prior notification requirement, a pilotage, and icebreaker escorting are navigational standards. Ice strengthening construction standards are CDEM standards. CDEM standards have a special feature as compared with two other types of standards. Ships cannot adjust to divergent CDEM standards during a voyage. Therefore, the Law of the Sea Convention requires coastal states not to apply their laws and regulations to CDEM or foreign ships unless they are given effect to generally accepted international rules and standards, GAIAs, even within the territorial sea. This slide shows the permissibility of three standards regulations in each sea area. A plus sign means permitted. A minus sign means prohibited. GAIAs means generally accepted international rules and standards. Unilateral means unilateral regulation by a coastal state which exceeds GAIAs. Three rules are relevant to the subject we are now discussing. First, in the territorial sea and international straits, a coastal state shall not deny, hamper, or impair innocent passage or transit passage. In the territorial sea, coastal states laws and regulations shall not apply to CDEM of foreign ships unless they are given effect to GAIAs. Thirdly, coastal states prescriptive jurisdiction in the EEZ is limited to adopting laws and regulations conforming to and giving effect to GAIAs. Now I'll examine coastal states measures in light of the relevant provisions of the Law of the Sea Convention. First, a requirement of prior authorization implies the possibility of denying passage, which is clearly in conflict with the duty not to deny innocent passage or transit passage. It is also clearly contrary to the very idea of rights of innocent passage or transit passage. Unlike prior authorization, it could be argued that the requirement of prior notification is compatible with the right of innocent passage and falls within the coastal state's competence under Article 21, paragraph 1A, relating to regulation of maritime traffic. In international national straits and EEZ, a coastal state does not have a unilateral right. A coastal state may adopt ship reporting systems only when they are approved by the IMO. The application of CDEM standards exceeding GAIAs is prohibited even within the territorial sea. For a stronger reason, it would be prohibited in international straits and EEZ. There has been much debate on the legality of a system of compulsory pilotage. Some authors, such as Beckman, have argued that a system of compulsory pilotage would have the practical effect of impairing or hampering the rights of transit passage and innocent passage. This is because the ships must stop to take on a pilot and pay for the pilotage service. Other authors, such as Bateman and White, have argued that a system of compulsory pilotage could be operated in such a manner as not to hamper or impair transit passage and innocent passage. For example, if pilots are readily available, they are efficient and competent, the fee is reasonable, the system does not have the practical effect of hampering or impairing the transit passage. To summarize, it is impossible to justify a prior authorization requirement under the normal rules of the Law of the Sea Convention. In contrast, it could be argued that a prior notification requirement is permitted in the territorial sea. CDEM standards regulation exceeding GAIAs is not permitted even within the territorial sea. Finally, the legality of a system of compulsory pilotage is controversial. In other words, Russian legislation includes requirements that cannot be justified by the normal rules of the Law of the Sea Convention. Therefore, the next issue is whether these requirements can be justified by a special rule, Article 234. This slide shows the text of Article 234. It provides coastal states have the right to adopt and enforce discriminatory laws and regulations for the prevention, reduction, and control of maritime pollution from vessels in ice-covered areas within the limits of the EEZ. The main elements of this article include ice-covered areas within the limits of the EEZ, non-discriminatory, due regard to navigation, and based on available scientific evidence. What is important is that Article 234 refers to neither generally accepted international rules and standards nor the approval of the competent international organization, unlike Articles 211, paragraph 5 and 6. The applicability of Article 234 to the territorial sea is the most controversial issue with respect to this article. There are two opposing interpretations. The first interpretation is that Article 234 applies only to the EEZ. The second interpretation is that Article 234 applies to the territorial sea as well as to the EEZ. The logic of the first interpretation is as follows. The limits of the EEZ is unequivocally defined by Article 55 as an area beyond and adjacent to the territorial sea. Article 234 applies only to the EEZ. Second, it would be absurd if a coastal state has broader powers in the EEZ than in the territorial sea. Therefore, powers under Article 234 are not broader than powers which the coastal state has in the territorial sea. The logic of the second interpretation is as follows. Powers conferred by Article 234 are broader than those conferred by the normal rules applicable to the territorial sea. It would be absurd if a coastal state has broader powers in the EEZ than in the territorial sea. Therefore, Article 234 applies not only to the EEZ, but to the territorial sea. According to the second interpretation, coastal states' powers under Article 234 is broader than the powers which the coastal states have in the territorial sea. That's why I call this interpretation a broad interpretation. In contrast, according to the first interpretation, powers under Article 234 are not broader than powers which the coastal state has in the territorial sea. Therefore, I call this interpretation a restrictive interpretation. Then, what is the content of coastal states' jurisdiction under 234? According to the restrictive interpretation, CDEM standards interpretation, coastal state powers under Article 234 are not broader than those under normal rules applicable to the territorial sea. As a result, according to this interpretation, CDEM standards regulation exceeding generally accepted international rules and standards is not permitted under Article 234. Also, the coastal state may not require prior authorization for entry into the ice-covered areas. In contrast, many authors who support the broad interpretation consider that CDM standards regulation exceeding GAIAS is permitted under Article 234. However, a total ban on navigation is not permitted. The requirement to have due regard to navigation under Article 234 presupposes that there exists a certain amount of navigation in ice-covered areas. It is unclear whether a requirement of prior authorization is permitted under Article 234. However, Professor Bartenstein argues that prior authorization is among the most effective means of preventive action, and that a due regard obligation is fulfilled by granting authorization in principle. In other words, by adapting the broad interpretation of Article 234, there is room to justify a prior authorization requirement. The last issue concerning Article 234 is its relationship with the Polar Code. The Polar Code was adopted by the IMO and entered into force in 2017. Amendments were made to SOLAS and MARPOL annexes to require state parties to these conventions to comply with the mandatory parts of the Polar Code. The Polar Code sets out additional requirements on ships navigating polar waters. While the Polar Code is the first mandatory standard peculiar to the polar sea areas, there still exists a gap between the Polar Code and the requirements imposed by Russian legislation. As Professor Sirkop has pointed out, Russian Arctic shipping legislation includes requirements that do not appear in the Polar Code. For example, ice pilotage and mandatory reporting are not required by the Polar Code. Then what is the relationship between the Polar Code and Article 234 of the Logarcy Convention? The Polar Code is a minimum standard to be implemented by flag states, while it constitutes guidance and provides a basis for the coastal state jurisdiction under Article 21, paragraph 2, and Article 211, paragraph 5. It does not limit the unilateral competence of coastal states under Article 234, which does not refer to generally accepted international rules and standards. Conclusion. Main points of this presentation may be summarized as follows. The requirements set out by Russian Arctic shipping legislation include those that cannot be justified under the normal rules of the Logarcy Convention. These requirements may be justified by adopting the broad interpretation of Article 234. The Polar Code does not deprive Article 234 of its significance. The Polar Code still has shortcomings and gaps. These gaps will be filled by the unilateral coastal state jurisdiction under Article 234. In this sense, the interpretation of Article 234 is extremely important. However, many uncertainties and ambiguities still remain about Article 234. We need to further discuss the interpretation of Article 234. That concludes my presentation. Thank you for your attention.
Thank you very much, Professor Wani. Very good presentation. I'd like to now turn the floor over to Evan Bloom, who will give his presentation related to Arctic shipping.
Mr. Burnett, thank you very much. I'd like to thank you and my fellow panelists. Good morning, good evening, etc. to everyone in your various time zones. So I'd like to, of course, thank the many very important sponsors of this conference for bringing all of us together. And I'm glad that the organizers have decided to add a panel focusing on Arctic, which has important connections with East Asia and the Pacific. So I'll be talking about the role that the Arctic Council plays in regional maritime governance. As you may know, the Arctic Council is celebrating its 25th anniversary this year. It will hold its biennial ministerial meeting on May 20th in Reykjavik. All the Arctic state foreign ministers will be attending in person, including US Secretary of State Blinken. So I attended the last two ministerial meetings. This one will now no doubt run a bit more smoothly than the last one, as the change in US administrations will in fact make it possible to once again adopt a ministerial declaration, as is the normal practice. As the Arctic Council is a high-level forum, not an it's a high-level forum, not an international organization. It consists of 8 states with territory above the Arctic Circle, plus indigenous groups referred to in the context of the Council as permanent participants. It also admits observers, and Japan, South Korea, China, and Singapore are all observers to the Council, among others. The Council is a forum focused on environmental protection and sustainable development. Per its founding document, the Ottawa Declaration, it does not have a role in military security issues. It's not treaty-based and has no formal regulatory role. I would argue that it does, however, play an important role in regional governance. It brings together the states in the region, allowing them to cooperate on many issues, including ones related to maritime areas. So marine issues have been a growing priority within the Council. With climate change and sea ice receding, there are many implications for marine policy for shipping, the environment, and for the indigenous and local communities of the Arctic. The Arctic Council has a major focus on maritime areas is understandable given that the central feature of the region is the Arctic Ocean, and all of the Arctic states are very much involved in maritime issues. In this context, the Council has been able to contribute to the work of the International Maritime Organization, and the IMO, recognizing this, sought observer status in the Council, and it is now an observer. Although the Council is not a regulatory body, it has provided the institutional basis for a series of treaty instruments on search and rescue, oil pollution preparedness and response, and scientific cooperation. All of those treaties have entered into force and are serving their intended purposes. Thus, the Council, while not an international organization, has played a significant role in development of international law. So the Council's maritime work often centers around one of its working groups, the Protection of the Arctic Marine Environment Working Group, also called PAIM, which was one of 6 standing Arctic Council working groups. PAIM's establishment itself actually preceded that of the Council as it was first established under the 1991 Arctic Environmental Protection Strategy, or AEPS. In November 2004, the ministers of the Arctic Council asked PAIM to conduct a comprehensive Arctic marine shipping assessment. This AMSA report, which was quite detailed and considered a landmark effort, was approved at the 2009 ministerial meeting in Tromsø. So PAIM works on many marine issues, including Arctic marine shipping, marine protected areas, resource exploration and development, ecosystem approaches to management, and Arctic marine pollution. At the coming ministerial meeting, it is expected that the ministers will approve PAIM's Regional Action Plan on Marine Litter. The Regional Action Plan will address both sea and land-based activities, focusing on Arctic-specific marine litter sources and pathways that will play an important role in demonstrating Arctic states' stewardship efforts toward reducing the negative impacts of marine litter, including microplastics, to the Arctic marine environment. Other areas of work include an Arctic shipping best practice information forum, which promotes implementation of the Polar Code. IMO has praised this effort and expressed hope that other regions will take similar steps. PAIM has a project on Arctic marine tourism. The US and Russia are leading a project on identifying and encouraging use of port reception facilities in the Arctic for ship-generated waste. And this is a key element in MARPOL for the prevention of pollution from ships. PAIM has been contributing to the active discussion at IMO on limiting use and carriage of heavy fuel oil. It approved an Arctic shipping status report on heavy fuel oil used by ships in the Arctic and has assessed risks associated with the use and carriage by ships of heavy fuel oil in the Arctic, fuel use in the Arctic, shipping incidents involving release of HFO and other fuels in the Arctic and effects on the marine environment, and best options to use if HFO is banned. So all of this means that the Arctic Council works on shipping-related issues, but it's not a regulator per se. Given the importance of marine issues for the Arctic, relevant discussions aren't restricted to the PAIM working group. Other Arctic Council working groups also work on marine issues. So for example, the Emergency Prevention, Preparedness and Response Working Group, EPPR, has worked on search and rescue and marine environmental response. I should mention that under the Icelandic chairmanship, so there's a block of 2 years where the chairmanship of the council rotates among the 8 Arctic states. So under the Icelandic chairmanship, there has been considerable attention paid to marine issues. Iceland's priority has included the Arctic marine environment, including plastics, microplastics and marine litter, blue bioeconomy, and sustainable shipping. It has held a series of meetings on the issue of marine plastic pollution in particular. So within the council over the past decade, there's been considerable attention, but perhaps not a lot of progress on how the council should provide leadership on marine issues, and in particular, marine conservation issues. Indeed, there's been recognition that the council has broad interests in marine stewardship that could benefit from new structures. The council adopted its second Arctic Marine Strategic Plan covering the years 2015 to 2025. And the council established a task force on Arctic marine cooperation in 2015 to assess the future needs for a regional seas program or other mechanism as appropriate for increased cooperation in Arctic marine areas. Excuse me. The task force tried to look broadly at the future of the conservation and sustainable use of the Arctic marine environment and how the Arctic Council should approach this. The task force looked at a broad array of precedents, including those outside of the Council. The task force identified a wide variety of marine issues that should be worked on. In particular, it said that there was a need to extend the reach of Arctic regional cooperation throughout the entire cycle of marine stewardship, from planning of scientific research to obtaining the requisite knowledge, including traditional and local knowledge, to carrying out observations and monitoring, conduct of scientific assessments, to formulation of policy and recommendations, implementation of policy, and monitoring and assessment of policy effectiveness. It recommended the establishment of a new Arctic Council subsidiary body to work on various issues, but in 2017, the ministers did not agree to take that step. Excuse me. At the last ministerial meeting 2 years ago in Rovaniemi, the ministers agreed to create what was called an SAO-based mechanism to facilitate further cooperation on marine issues. So SAO stands for Senior Arctic Official, and they are the heads of delegation for each of the Arctic states for the regular work of the Council, that is, when the ministers are not present at the biennial ministerial meeting. The good thing about involving the SAOs is that the focus will be at the highest diplomatic level of the Council. A drawback is that the SAOs themselves aren't necessarily marine experts, and they are busy people, sometimes with quite broad portfolios, so they don't necessarily have the time to work on details of the marine issues. So during the past 2 years, the SAO Marine Mechanism held a series of virtual discussions among SAOs and national experts plus observers. We'll see soon whether this effort will continue during the 2-year Russian chairmanship, and if so, what its mandate would be. My sense is that this SAO Marine Mechanism has not been very robust and has tended to involve rather general conversations without a lot of forward progress. A key consideration in these efforts is whether ecosystem-based management can be mainstreamed into the Arctic Council and its maritime work. This is often difficult because of the transboundary way that this comes up. After all, it makes a difference in legal and administrative terms whether we're talking about actions within areas beyond national jurisdiction or within national jurisdiction, and actions by multilateral bodies that are to have an impact on, especially legally binding impact on areas within national jurisdiction, can be sensitive or controversial. As a general point, I'd say that the Arctic Council sits comfortably so within the context of UNCLOS as a general matter. There's really no conflict between the law of the sea as set forth in UNCLOS and the activities of the Council. A major current question is what role the Council might play in the context of the so-called BBNJ agreement. So in that context, I'm referring to the negotiations at the UN of an internationally legally binding instrument under UNCLOS on the conservation and sustainable use of marine biological diversity of areas beyond national jurisdiction, which is, of course, quite a mouthful. These negotiations were heading into their final sessions when the pandemic hit and will be resumed in coming months. There are a number of implications for the Arctic in the BBNJ negotiations. So to simplify this a bit, a key question is whether, if part of the high seas portion of the central Arctic Ocean deserves some sort of protection, let's say a limitation on fishing to protect the ecosystem, will a BBNJ conference of the parties be able to mandate that action? Or would it defer to a regional body with relevant jurisdiction? If there is no such, if there is no such body with relevant jurisdiction, what would happen then? The Arctic Council, on its face, would not seem to serve that purpose very well because it is not, as we've discussed, a regulatory body. It has no authority to mandate the creation, for example, of a no-take area prohibiting fishing for its 8 members, much less for non-Arctic states. Moreover, the 2018 Central Arctic Ocean Fisheries Agreement, which has been ratified by all 10 signatories except for China so far, and thus isn't yet in force, does not set up a regional fisheries management organization. And until it does, its process does not create a body with sufficient authority to establish marine protected areas and the like. That said, the terms of the BBNJ agreement are very much up in the air, and perhaps there is some contribution that the Council, the Fisheries Agreement, or related science bodies or working groups can make to the implementation of a BBNJ regime. BBNJ is intended as an implementing agreement under UNCLOS, so it will have great relevance to marine regulation of the high seas pretty much everywhere, and the Arctic Council is no exception. I should note that BBNJ is not just about marine protected areas or area-based management tools. It also covers issues like rights to marine genetic resources, which would also have implications for the high seas areas of the Arctic. So much depends on whether a BBNJ agreement with broad support can be negotiated. Even if it has broad support, it could take many years to enter into force. And of course, the effectiveness of the BBNJ agreement may depend on whether key states join it, and for the Arctic, whether the Arctic states are ultimately parties. So I think I will stop there and turn it back to our moderator.
Thank you very much. Very interesting remarks. Going now to our fourth speaker, Dr. Sun. But initially, we're going to have a video that she has prepared, and then she will follow with her remarks. So I'd ask the host to initiate the video at this time. Thank you.
Hi, good afternoon from Malmö, Sweden. My name is Sun Zhen. I work at the World Maritime University Sasakawa Global Ocean Institute as a research officer. I would like to join my panelists, co-panelists, by thanking the organizers for giving me this opportunity to share with you on the study. I have been following COLP annual conference for many years now. This is the first time I participate as a speaker. I'm very grateful for this opportunity. This topic is something that I've been pondering on for quite some time and had discussion with different professors, including my previous boss, Professor Robert Beckman, is that how to promote port state in enforcing and promoting compliance of international regulation of shipping. And today I would like to apply this discussion in the context of Arctic shipping and the role of East Asian port state. So I start the presentation with 3 hypotheses. Is that international shipping has the potential to cause serious harm to the Arctic marine environment. Some might be irreversible due to its really unique condition. Port and port state has a special role to play in terms of implementing international regulations. And with a sufficient legal basis, East Asian port states have both political and economic interest in promoting clean and shipping in the Arctic. So for this presentation, I would like to lay down the groundwork of what is the current and future situation of shipping in the Arctic, and what does that mean for East Asian port states, how that is connected to them. Then moving on to discuss port state jurisdiction as defined under UNCLOS, and wanted to clarify or trying to seek clarification on some of these specific matters before port state can invoke such enforcement jurisdiction. Many of you have seen a lot of these predictions and also images coming from different studies, different institutes. I took those from NOAA. They monitor Arctic ice coverage on a daily basis. What I want to highlight here is just to show that there's a continued declines of ice coverage in Arctic Ocean in all seasons. So the first chart shows average coverage of March, which is declines of 2% annually. And the bottom chart is the sea ice coverage during winter seasons. It is the statistics, the different lines is the statistics of the past decade, and all of them have been under the medium line of the two previous decades. So during the last 10 years, Arctic Ocean has severely been affected by the raising of temperature as a consequence of climate change. What does that mean for shipping? Is that some of these previously remote areas are going to be ice-free. It is opening up for the more presence of shipping in the Arctic Ocean. We have seen there are extensive studies to show where these shipping lanes could be and what does that mean for the international commercial shipping. It's a shorter route, it's a shorter time, and also there is an increasingly longer season of the shipping navigation season in the Arctic. I like to use the left map because it shows a connection between human activities and the potential opening or the use of shipping routes. The green dots shows the population located in the Arctic region. Yellow ones are shipping patterns. The green ones are the offshore, including the offshore activities, with the orange line indicating potential shipping routes. The green ones are the division of large marine ecosystem in the Arctic. Those are the factors that we have to take into consideration when discussing shipping in the Arctic. What are the drivers and what would those drivers bring in in terms of types of shipping, and what kind of impact would those different shipping patterns cause to the Arctic marine environment. Shipping is not completely benign to the environment. Those environmental impacts are not limited to discharges or waste that is dumped from the ship themselves. There are going beyond disruptions to the bigger or the larger ecosystem, including marine life, as well as might cause impact on the human population living in this region. What the international community has responded is try to design to take a precautionary approach, try to design a better regulated framework for ships that are going to use the ice-covered areas that is represented by the Polar Code developed by IMO. So the legal framework, as we spoke just now, it focuses on the rule of flag state, to rely on flag state to ensure that ships under their registration would comply to these international regulations. It is also been recognized that there are some deficiencies of exclusive flag state jurisdiction, and that's where ports came in. Ports are the connection between land-ocean activities. It is the departing and ending point of any sea voyage. So ports, by default, has a particular role in terms of enforcement and compliance of international regulation of shipping. Moving to the 3 East Asian states, the point I want to highlight is that all 3 of them are major shipping states. They are on top of shipping registration. They are the major market in Asia, and also they have well-developed port infrastructures. They are key players at IMO, which help to design and also in promoting implementation of international regulation of shipping. All 3 states has also shown an interest in engaging in Arctic affairs by becoming observers to the Arctic Council. Since 2013, all 3 states has developed various domestic measures, policy white paper to promote their engagement with the Arctic states. And also they have been on the front line to implement Polar Code. I want to use Northern Sea Route to highlight these connections. So this is a statistic coming from 2018. They recorded 27 full transits of the Northern Sea Route. I highlighted with the red line is that 16 out of these 27 full transits have one end linked to a port located in one of the 3 East Asian states. I use the blue line to highlight that this transit is done by a foreign flagged vessel compared to the port state. And 11 out of the 16 transits that linked to Asian countries is done by a foreign flag. This map is from 2020. The first thing I want to highlight is the increase of numbers in terms of full transit of Northern Sea Route. In 2018, the number was 27, and here is more than doubled, stood at 64. And you can also have a virtual image of where those 3 states are located and how they are connected, the usage of Northern Sea Route. I haven't found many statistics or maps that is well done to indicate the connection of the international trade between Asian states and northern part of North America. That's Alaska or all the way down to Canada. But it doesn't mean that they don't exist or the number couldn't increase. The incentive and the logics are the same. Those 3 states, because of their potential market needs and also their connections with the international trade, they are going to be a hub for ships that either departing to or coming back from shipping in the Arctic waters. So moving to legal framework, we mentioned that it's mainly relying on implementation by flag state. But MAPO, for example, and subsequently all major IMO technical conventions introduced a concept of port state control. So port state has been given a certain jurisdiction to double function as a backup or check for flag state implementation. So under MAPO, the port state can inspect the ship to verify whether it has a valid certificate and to check the condition that is corresponding to what is stated on the certificate. If the ship failed to show that, it can be detained by a port state. So the detention of a foreign flagged vessel is limited or linked with the certificate and the condition of the ship or its equipment. In terms of discharges violations or pollution violations of MAPO, the port state or the port can initiate inspection and to verify if the ship has discharged any harmful substance. But the subsequent action is limited to provide such report to the flag state for the flag state to take action against the violation. This inspection can also be done upon a request by another member state who provides sufficient evidence to demonstrate such discharges. Then again, here the port state action is limited to providing such inspection report to the requesting state or to the flag state. So under MAPO, port state control is limited to inspection of certificate and the condition. It doesn't have direct enforcement jurisdiction over violation conducted by a foreign vessel. MAPO predicts UNCLOS. So when UNCLOS was negotiated, it took into consideration of port state measures developed by MAPO and in a way expanded the scope of port state jurisdiction. It given port states a right to investigate, also to institute proceedings for violation that is conducted by a foreign vessel outside the jurisdiction of the port state in violation of applicable international rules and standards. This is indicated by the word may. So it is the port state's discretion to decide whether they want to utilize such right. And such proceeding can be initiated based on request by a state, or the port state can initiate it by itself if the violation has caused or likely to cause pollution to the port state. Similar to the language of as may, the port state is only required to comply with the request for inspection and initiate proceeding if it considered it is as far as practical. So UNCLOS did not specify what it means by practical, whether it is the port state to present that it considers it's impractical to initiate any proceedings, or it is up to the requesting state to say they think the port state hasn't done enough. So this is one thing that needs to be clarified before port state want to initiate the enforcement jurisdiction over a foreign vessel. There are other conditions, and many of them also need further clarification, not just based on the terms as we used. First, it is required to have evidence to prove such discharges. It didn't specify what type of evidence, also who has the duty to prove. Under MAPO, it was clear that the requesting state must provide evidence to the port state to initiate inspection, but under UNCLOS, it is left open. Also, UNCLOS 218 is limited to discharge violations. It's a discharge coming from a vessel. That means it's pollution related. And to some scholars, it is clear that others may argue otherwise, whether this means it excludes other types of environmental impacts associated with ship, particularly such as invasive species that is regulated currently under the Ballast Water Convention. There are also ongoing discussion on how to deal with underwater noise. So whether those would fit into the definition of pollution as discussed by UNCLOS or not. The third one is relatively straightforward, to be outside of the maritime zone of the port state. The fourth one is the discharge is violation or in violation of applicable international rules and standards. This is one of the strongest feature of UNCLOS. It is that UNCLOS functions as the framework or umbrella convention. Some of the specific rules need to be supplemented by those subsequent agreements and instruments developed by states through competent international organization or general diplomatic conference. In terms of shipping, that refers to IMO. However, there hasn't been any authoritative interpretation or clarification on what are those generally accepted international rules and standards. So the one that I would agree most is the ILA study in 2000 done by a committee on coastal state jurisdiction, is that in order for the term rules of reference to have any added value, it should not be limited to customary international law or other binding instruments between the relevant parties, because the states have already under obligation to comply with those two types. So it has to go beyond that. And then it is not clear what is left for this international rules and standard. I have pondered this question many times, and I think I'm still not entirely clear whether, for example, MARPOL, we think MARPOL, consider MARPOL as generally accepted, but when it's come to a specific regulation, whether that means MARPOL as a whole being accepted, or we have to refer to specific rules to say that this is a generally accepted international rule. And under MARPOL, it allows states to object and hence not binding by any amendment, but by using the rule of reference, if they are a member to UNCLOS, that means they have to be bounded by this agreement, by this amendment anyway. Also, whether this term extends to non-binding instruments. Those are the things that I think need further clarification in the context of Article 218. 218 can be invoked upon request by states that has been affected by such violation of discharges, or it can be initiated by port state itself. The condition for that is the discharge has caused or is likely to cause pollution to the port state. I would like to throw a question out there. This is inspired by a book that I recently read. It's air pollution and potential GHG regulation. Is that whether or would accumulating effect of air pollution and greenhouse gas emission qualify as a pollution that is affecting the maritime zone of the port state, and give the legal ground for port state to enforce jurisdiction over violation of air pollution and potential GHG regulations. So this, again, is a question that I've been thinking, and I would welcome your comments or suggestions. With that, I would like to conclude that there is a legal basis for port state enforcement jurisdiction over violations of MARPOL, to be specific, when they are using the Arctic Sea route. It is as Arctic far as practical for port state to invoke such enforcement jurisdiction. They could do so by showing their collaborating with Arctic port states and going through different international forums. With that, I conclude this presentation, and I thank you for your attention. If you have any questions, I'm here to answer them. Thank you.
Thank you very much, Professor Sun. Very informative presentation. At this point, we are going to go over some questions that have come up from the audience. I'll start off the first question. There are suggestions that the US or Canada should work to set up organizations similar to those that were successful for the St. Lawrence Seaway to finance through ship tolls, navigation aid improvements, weather forecasting, SAR, salvage, and oil pollution resources. Is that approach practicable? Evan or Aldo, I think you might have some views on those.
I can perhaps offer a few words. And I did mention this in my presentation, actually. It's one of the ideas that is floating out there. Because, as I indicated in my presentation, one of the questions is really what kind of institutional framework will be put in place to administer the corridors. So clearly, the St. Lawrence Seaway Commission model is one idea that is out there. And I don't know how much the audience would be aware of how this commission works. It's bilateral, but at the same time, there is an American portion and the Canadian portion. And the way they work is very interesting because of the high degree of coordination. Now, what is interesting to recall, too, is that in the Arctic Leaders Summit before President Obama's term of office came to an end, and Prime Minister Trudeau actually issued a statement where they indicated willingness to cooperate actually on sustainable shipping. And Prime Minister Trudeau's portion of that statement included cooperation on low-impact corridors. So in a sense, there is a kind of a political note that has been said there that could potentially leave that as an option.
And for my part, I would say all of that makes good sense to me. The relationship between US and Canada is, of course, very close, but there have been differences on a number of law of the sea questions. On Northwest Passage, we have a number of maritime boundaries that still have not been resolved, but the countries find a way of muddling through. And so when there's a need for discussions, both countries are open to them. I mean, we've had differences over Nordregs, for example, and the legal issues connected with them. But I would imagine that if there were a true commercial need, that would drive the governments together to resolve whatever problems they have.
Yeah, I just think it's an interesting model because it allows you to sort of keep the agreement to disagree on whether it's an international or Canadian waters. It allows you to have corporate structures where Indigenous people could have say, and of course for shipping, it makes for a reliable, efficient way to move from point A to point B. So I'll go to the next question. This question is, in crafting of the policies regarding Arctic navigation, how much participation do the Indigenous communities have?
That is an excellent question. When the Canadian Coast Guard first launched the idea of low-impact corridors in 2015, they essentially put forward a map and without prior consultations. And essentially the initiative has had to have a kind of a reset. So it's now a consultation process underway with many communities in the Canadian Arctic, because corridors produce a range of impacts, local impacts. And a number of things have emerged. For instance, one of the things that has emerged is that there are at least 7 classes of different kinds of impacts, lots of potential impacts at the local level. And essentially each section of the corridor will have to take into consideration, as it were, local area impacts. The uses of the ice might be different, for instance, from one area to another. So the federal government essentially has very clearly indicated its commitment to UNDRIP. And essentially, UNDRIP includes a number of important principles, including the rights to lands, territories, and resources of indigenous peoples, but also a duty to consult and, in many instances, to secure free, prior, informed consent. So what you see here is not just a public consultation process, not at all. Indigenous peoples are rights holders, they're not stakeholders. And therefore, they engage with the government of Canada on a government-to-government basis, on a nation-to-nation basis. And as a result, that fundamentally changes how the governance of shipping in Canadian Arctic waters is going to take place. So the answer to your question is yes, you can expect high-level inputs.
Okay, thank you. The next question is also directed to Dr. Sherkop. Canada has historically claimed the Northwest Passage are internal waters and not a strait used for international navigation. In your presentation, you made the observation that Canada has moved from a unilateral to multilateral approach to the regulation of shipping in the region. You also point out that the use of corridors may be voluntary. In your assessment, do you think that this means the Canadian government has de facto abandoned the position that the Northwest Passage are internal waters?
Not at all. There's absolutely no question about the legal status claimed by Canada over those waters, and which has been asserted actually in a number of different ways. Even in one of the land claims agreement, the Nunavut land claims agreement, for instance, is very interesting that it asserts, and this is an agreement within essentially with indigenous peoples, with the Inuit population of Nunavut, that Canada's sovereignty over the waters of the Arctic archipelago is supported by Inuit use and occupancy. So there is no question, at least from an indigenous perspective, that the question of sovereignty is essentially non-negotiable as I see it. One has to look at here not only Canada, a nation, but has to look also the issue of the indigenous rights interests here, and of course the growing general international law concerning indigenous rights, which creates an interface with the law of the sea. And what I would underscore, though, of course, is that Canada has moved from unilateralism to multilateralism in the regulation of shipping, so rules and standards for shipping, not the legal status of those waters. And if you go back to the Arctic Waters Pollution Prevention Act rationale, one of the reasons for it was we didn't have international standards that were high enough for polar shipping. So essentially, that was a starting point. But once we did have scaled up international standards, then in essence, Canada, and for that matter, the Russian Federation and other Arctic states, essentially saw the wisdom of the higher standards applicable to all Arctic waters. So essentially, what you have is Canada endorsing the international standard for shipping, including in Canadian Arctic waters, because it is the highest possible standard at this time. It not only matches Canada's previous unilateral standards, in some instances, it actually exceeds, for instance, with respect to the regulation of sewage. So I would make a distinction between the regulation of shipping and Canada's claim with respect to legal status of Arctic waters. Thank you.
The next question was directed to Evan Bloom. You pointed out that the Arctic Council does not include a mandate to deal with hard security issues, a clause you helped negotiate in 1996 to facilitate American entry into the Arctic Council. Since 2014, there has been a continual increase of naval activity in the Arctic region. This includes many of the advanced nuclear-powered and armed vessels of Russia, United States, and other NATO northern state navies. This means there's a growing disconnect between the Arctic Council efforts to regulate the commercial side of shipping in a multilateral cooperative manner versus the increasing conflictual naval interactions in the region. In your view, What does this growing complexity and paradox mean for long-term security in the region?
So thank you for the question, and I think it's a good one. There is a growing complexity in Arctic geopolitics about these security questions and how they relate to the Arctic Council as a forum. I have a couple of thoughts on that. One is that, in my view, the Arctic Council makes a significant contribution to regional security, even though it doesn't have a mandate to work itself on military security per se. It provides a forum for the Arctic states to come together and discuss diplomatic issues in general. And it is a consensus-based forum that where, for example, the US and Russia are able to talk and cooperate in a way that is very difficult in a large number of other fora and contexts. So I think it contributes to security in general. But I would say that the issues and concerns related to security, military security, and naval activity are rising when it comes to Arctic matters and among the Arctic states. And so even if the Arctic Council itself may not be the right place to hold those, because you need to bring in military and national security officials to have those sort of discussions. You could have separate fora, sui generis fora. There's been discussion of bringing those sort of discussions into NATO, although I'm not sure that the Russians think that that's the most wonderful idea. But there are ways of, first of all, bringing allied states together to discuss their military concerns, but also ways of reaching out to the broader scope of countries, perhaps for one-off meetings without establishing a new organization, if you don't want to go that far in the immediate future.
Thank you very much. I think we have a little bit more time. I just wanted to ask any members of the panel if they have questions for other panel members that they would like to pose, because we've completed the questions that were submitted by the audience.
If I can perhaps ask one to Dr. Sun, which fascinating presentation, I thought, with respect to the port state control in particular. And I'm wondering, at one point there was a proposal for a concerted inspection campaign in the Paris MOU, I think focusing on the polar ship certificate. But I understand that there were some issues. I wonder if perhaps you follow that and maybe tell us whether there might be perhaps a future campaign.
Thanks, Aldo, for pointing that out. I think since Polar Code went into force, Paris MOU and the Tokyo MOU had joint statements saying they're going to promote the implementation of the Polar Code on inspection and checking the certificates. I haven't seen any report coming out of that specific action, but I would think that would be, in my opinion, that would be the perfect kind of starting point for port state to organize their actions and standard on a regional basis. So it covers, at least on the Northern Sea Route side, covers both ends of where the ship's coming from. Thank you.
Okay. Thank you. At this time, our time has come to end. I do want to thank the hosts for actually going to great lengths to make sure that the technology was work tested and went very smoothly from my point of view. I also want to thank the speakers. These were very useful presentations, thought-provoking, some excellent graphics. So I think for anybody that's interested in Arctic shipping, this was a feast of good ideas, thoughts, and considerations. So at this point, I will close the session on Arctic shipping and thank everyone and wish them a happy morning, afternoon, or night. Thank you.